This conference will now be recorded.
Hi, this is Stephanie Schneider. Thank you for joining me on August 7th, 2020 for my webinar, 5 Must-Know Reasons Parents Should Create a Legal Plan for Their 18-Year-Old Child and Minor Age Children. So the first reason we're talking today about creating a plan for an 18-year-old who's now become an adult is because we want you to have to avoid a legal guardianship in the court, which can be costly as well as result in a loss of privacy should your young adult child have an accident or an illness and become incapacitated. The second reason that we're hosting today's webinar is to enable you to make your young adult child's medical and financial decisions independently when he or she is either temporarily or permanently incapacitated. We also want parents to be enabled and empowered to settle a lawsuit for any injuries that their young adult child has sustained. Again, this is important if your child is now incapacitated and can't make financial decisions for themselves. We also want families to be empowered to name a trusted person to make their minor child's medical decisions if the parent is away, perhaps on a vacation or a trip, or just simply unavailable and the child requires medical attention. And last but certainly not least, we hope that as a result of attending today's webinar or watching the recording, you'll be empowered to choose trusted people to serve as guardian of your minor child in the event of your incapacity or your demise. So let's start our discussion today by talking about our young adult children who have now had their 18th birthday. Well, for the child, they're probably very excited because they're thinking that now they get to make their own decisions. But for parents, many parents don't realize that when their child becomes a legal adult, the parents can no longer make medical or financial decisions for their child. The child or the young adult now has all of the same legal rights that you and I as parents have. This means your 18-year-old can now vote. Your 18-year-old can enlist in the military. Your 18-year-old can get married and they do not need our permission to do that. Our 18-year-old children can make their own medical decisions, and because of the privacy law in our country called HIPAA, the doctor does not need to contact us as the parents to either tell us that our child visited the doctor's office, and the doctor has no obligation to inform us of the purpose of the visit or any treatment. In addition, our 18-year-old children can now make their own financial decisions. So if, for example, they might have saved some money in a bank account, or perhaps when they were born or reached certain milestones, family members gave them United States savings bonds, these children now have the right to access those financial assets. They don't require our permission to do so. So these are just a few of the legal rights that our young adult children have. And we're going to talk about the importance of putting a legal plan in place for them so that you as the parents can make decisions for them should they unexpectedly become incapacitated. Now, Usually around the time of graduation, May or June, families are very busy either planning the last family vacation where everybody will be together before the 18-year-old might go off to college, or we might be planning the graduation party and very excited about it. Or maybe we're sending our child to backpack through Europe before going away to college. And some of our children are preparing to enter the military because they've enlisted. So there are two questions I'd like everybody to think about. The first question is, who will make medical decisions for your young adult child if they become incapacitated? Believe it or not, there is nothing in Florida law that says when our child turns 18, we as the parents can still make medical decisions for them. Since they have that right, they need to give legal permission to mom, dad, or another trusted relative to be able to be their advocate, to speak for them, to have permission to communicate with doctors, to be able to request a second opinion. Or if the parent does not like the hospital or the treatment facility and believes another facility is better for their child, they need to have legal permission to authorize the transfer and the discharge. I also want you to ask yourselves, who will make financial decisions for your young adult child if they become incapacitated? What if there are assets or accounts in their own name? Now, you've heard me use the word incapacitated several times. So what does incapacity mean? Well, it can mean that there is an illness, a disease process, an accident, or some sort of an event that affects our young adult child's ability to exercise judgment, reasoning skills, which in turn means they may not be in a position to make proper medical choices for themselves, to understand what the test results show and what the options for treatment are. So if they're incapacitated and they can't give informed consent, absent an emergency, the doctor or the hospital is going to need either somebody to be appointed guardian to make the medical choices, or they're going to ask, does this child have a legal document called a designation of healthcare surrogate? So sometimes unanticipated events happen, things that we just can't predict and we certainly don't plan for. Probably the most common is an automobile accident. Now, Florida is not unlike many states in the country where statistics show that the highest rate of automobile accidents occur between the ages of 18 and 27 years of age. So, although we've spent a lot of time teaching our children how to drive, expressing to them the importance of remaining aware and focused, not looking at their phone, not paying attention to text messages that might come in while they're driving, accidents do occur, and they may be due to no fault of our child, but due to somebody else's unawareness. So we want to be ready should any unanticipated event occur so that we don't have to go to court and do a guardianship. Many years ago, I received a telephone call from a personal injury attorney, and he was recommending me to a set of parents whose 18-year-old child had just been in an automobile accident, was unconscious, taken to the hospital, and he had not yet come out of the coma. Now, as we expected, this young man did not have any legal plan in place, so the hospital informed the parents that the parents were not going to be allowed to make medical decisions, and the hospital requested that the parents go to court and be appointed legal guardians of their son. Not only was it necessary to be appointed guardian over the person in order to make the healthcare decisions, but it was also necessary for them to be appointed guardian over their child's assets. Now, you might say, well, what asset would an 18-year-old have in their name? Well, the personal injury attorney they went to felt that the accident was caused by the other vehicle. And so the attorney contacted the insurance company for the other driver, and the insurance company did their investigation very quickly and realized that their insured was at fault. They did not want to have to go through a lawsuit, and so they immediately offered to pay the policy limits to this young man. However, because he was in a coma, he had no ability to understand and accept the settlement offer. So for that reason, his parents also needed to be appointed guardian over property so that they, on his behalf, could accept the settlement. Now, this young man was very fortunate. He did come out of the coma, and over the next year and a half, through the dedication of his parents and attending many physical, occupational, and speech therapy sessions, he regained a lot of his physical as well as his cognitive abilities. So about 2 years after the guardianship had been opened, we were able to go before the judge and request that the guardianship be terminated and all this young man's legal rights be restored. Now, that's one of the happy ending stories that I love to share and I enjoy looking back on. And we made it a point to put in place for him the legal documents that we're going to talk about today. So in the event anything else were to occur in the future, I would not get the call telling me we needed to go back to court to do another guardianship. Guardianship can be expensive, and many things that are filed in a guardianship are considered a public record. And now with the advent and the advances made by technology, many things can be viewed on the computer that are filed in the courthouse. So I do encourage everybody to be proactive after today's webinar and have your young adult children create a legal plan to avoid a guardianship. Another type of incapacity that could happen when your young adult child is away at college is they could fall ill. They could have some sort of an infection. It could affect how they act, how they behave, their ability to reason. And so that's another example of why we are encouraging parents to work with their young adult children to put a plan in place. Another unfortunate example, but we can't stick our heads in the sand like an ostrich and ignore that this could happen, is that there are shootings that happen at schools, whether they are public schools, private schools, colleges. Many of you may recall that about 15 to 18 years ago, there was the unfortunate shooting that took place at the campus of Virginia Tech Institute. And this was after HIPAA had become the medical privacy law in the United States. And on the morning of the shooting, when it became apparent and it was featured in the news, parents who were at work or at the gym or at a place where they saw the news immediately began to call the hospital where the students were taken by ambulance. And because of the HIPAA law, the operators at the hospital were instructed to inform the callers that they could not answer any questions about whether or not their child had been taken there or the condition of their child. Well, this angered and frustrated many parents. They did not understand why they were being told this. In their mind, they were the parent and they had every right to know what was happening with their child, as well as the right to make medical decisions. So I use this example as a lesson for all of us to learn from so that we don't repeat the same history should this occur again. So I want you to imagine for a moment, what would happen, what would you do if you received a telephone call from your child's college roommate, and the roommate was telling you that she was calling you because your daughter was acting strangely. Her speech was incoherent. She was just not herself. The behavior was off, and the roommate did not know what to do and didn't want to leave her alone out of the fear that she might become unconscious or she might be hurt. Well, this is an actual real life story that occurred about 5 years ago when one of my employees received a call from her child's roommate. Her child was attending college in another part of the country, and the roommate was very concerned and just didn't understand why my employee's daughter was acting the way she did. She knew that the child had not been drinking alcohol, but she didn't know what was going on. Now, I want to take you back to what we did before the day we received this telephone call. So when my employee's daughter turned 18 in her senior year of high school, we made it a point to sit down with her and talk about why it was important for her to have certain legal documents in place as an adult so that her parents would be able to assist her with making medical and financial decisions if she was ever ill, disabled, or incapacitated. And she allowed us to create the documents for her. The documents were signed before she went off to college. She brought a set with her, and those were given when she was admitted and moved into her dormitory. And her parents had a set with them. And we also made it a point to scan them so there was an electronic copy. Now let's go back to the morning that my employee received this disturbing phone call from her child's roommate. Well, as you can imagine, she was very concerned about her daughter, and she couldn't just get in the car and drive to the college because we're here in Florida and her daughter was all the way in Rhode Island. She knew she was going to have to get on a plane, but she was relieved knowing that her daughter had the necessary legal documents in place. So she instructed the roommate to drive her daughter to the nearest hospital. Once they got to the hospital, we emailed the documents to the admissions office, and because of that, they willingly got on the phone right away to speak with the mother. So all of this was able to happen very quickly. At the same time, the parents were getting on a plane to get up there. So they were able to be informed and they were able to make the medical decisions for her, which meant that they were avoiding a legal guardianship proceeding. Now, my second query is, what would you do if your child was in a car accident, and when he arrived in the emergency room, he was unconscious. So this is very similar to the story I shared a little while ago about the young man that we had to do the guardianship proceeding for. So keep in mind that the medical privacy law called HIPAA is going to prevent medical professionals from telling us as parents what is going on with our children, and will even prevent us from making the necessary medical decisions if we do not have for them a designation of healthcare surrogate. So this is a crucial document that everyone should have as soon as they become an adult. There is no magic age that we turn that we should wake up and say, today is a good day for me to sign a designation of healthcare surrogate. We may not get that opportunity. So we need to do this on our 18th birthday. So the word surrogate means somebody that we choose, that we trust, that we have confidence in to be our medical advocate. Somebody that's going to speak for us when our ability to communicate is impaired. It doesn't just mean that we're unconscious. It could mean we're conscious, but perhaps we hit our head in the car accident and there's swelling in the brain, and we are having great difficulty taking in information, being able to use our reasoning skills, and then arrive at a medical decision. So it's very important that we designate a healthcare surrogate in writing to do these things for us. Now, there is no requirement in the Florida law as to how many people we name. So I want everybody to think about naming a primary surrogate and naming a successor, or what we refer to as an alternate surrogate. Well, why do we do this? We do this because I don't have a crystal ball, so I can't predict whether the person that is named as the first surrogate will be able to and available to make the healthcare decisions when the time comes. What if the surrogate is incapacitated? What if the surrogate is out of the country? And so that's why our plan needs to have an alternate surrogate named. We can name 2 surrogates, we can name 3 alternate surrogates. Another option is that the adult child might want to name both parents as co-surrogates to make the decisions together. And that's also another great option to consider, in addition to having somebody else named as the alternate surrogate. Now, 2 years ago, Florida updated its designation of healthcare surrogate law, and it gave us 2 more choices to include in the document. So the first choice you have is to indicate whether you want your surrogate to begin acting for you immediately, or only when your physician examines you and determines that you lack the ability to give informed medical consent. The second choice that you now have is you get to decide whether your surrogate will have immediate access to confidential medical information, or only have access in the future once your doctor determines you lack the ability to give informed consent. And the answer to these questions does not have to be the same. For example, you might choose that your healthcare surrogate will act only when your physician determines that you cannot give informed medical consent, but you might want your surrogate to have access to medical information now to be supportive and help you make the right decisions. So that's one set of options that you might want to discuss with your young adult child. So just to recap, it's important to have a primary and at least one alternate surrogate, and you want to think about whether you want your surrogate to begin to make medical decisions now or in the future, and do you want to give them access to confidential medical information such as test results now or only in the future. One thing that's important for your young adult children to understand is they can update their healthcare surrogate document when they get married. So when they get married, they may prefer to have their spouse be their primary surrogate and their parents or another trusted family member to be the alternate surrogate. Or maybe they're not getting married, but they have a life partner that they would like to be their primary surrogate. So we can update the document as there are changes in their life. But it's important to have the document in place starting when they're 18 years of age. Now, the surrogate stands in the shoes of your child and can make all the kinds of decisions that your child could make if they were conscious, aware, and able to make the healthcare choices. So this would mean being able to make a treatment decision, being able to authorize surgery, being able to decide where they want to have the treatment or the rehab services provided. So think in terms of things that we get to decide every day that affects our bodies, that affects our medical condition. It might be that we go to the dentist for our annual checkup. They do x-rays, and then the dentist tells us that after looking at the x-rays, we might need a cavity filled, or we might need a root canal. Well, if something's affecting your child's ability to make that decision, then the surrogate can make that decision for the adult child. So hopefully you're starting to see why it is so important to have these documents when our child becomes an adult at age 18. The second important document for you to consider for your adult child is called a durable power of attorney. Now, this document serves a similar purpose to the healthcare surrogate, but it deals with all kinds of financial issues. So, for example, if you bought your child a car and you put the title to the car in your child's name, and then they become incapacitated, you want to have the ability to deal with the car. Well, having the durable power of attorney is the way to allow you to do that. Or let's take the example of a child who, after completing high school, isn't ready to go on to college. They need to take some time off and try to figure out who are they, what do they want to do, what will make them happy. So maybe your child, instead of going off to college or to a vocational technical program, decides they're going to get a job and start working. And they're living at home, so they don't have much in the way of expenses, and they start to put their paychecks into a bank account. And maybe they're working long enough for the employer and they're offered to participate in a retirement plan. Or maybe you encourage your child to put some of their earnings into an individual retirement account and start saving for their future. Well, any kind of retirement account, whether it's an IRA or a 401k, can only be put in the name of the employee, which means parents' names cannot go on the account with their young adult child. So how would you access the account if your child had the car accident or your child is incapacitated? You wouldn't be able to access the account without having the durable power of attorney. And using this same example, what if your child is working for 3 years before they decide they're ready to go to college? And because they're working and they're earning a pretty good wage, they have to file a federal income tax return. They can no longer be included as a dependent on your personal income tax return. Well, if your child is ill or incapacitated and they can't sign the income tax return that the accountant prepared, what are you going to do? So rather than it become a dilemma, the durable power of attorney can give the authorization to allow you to sign the tax return so that it gets filed timely. And should the child be entitled to an income tax refund, you'll then be able to receive that check and deposit it into their bank account. So while many young adults may not have accumulated a lot of wealth or a lot of assets, there can be assets that are in their own name for which you really need to have the durable power of attorney. Now, there are some other legal documents that we refer to as medical advance directives, and this simply means that they are healthcare related. So I'd like to touch on these so that you're aware, and when you sit with your young adult child, you can discuss whether your child would like these documents as part of their plan. The first one we call the HIPAA authorization. So you've heard me talk about how HIPAA is the medical privacy law in our country. And because of HIPAA, anybody that is not authorized to receive confidential information would not have access. Now you might be thinking, well, if my child signed the designation of healthcare surrogate, wouldn't that be enough to give me the ability to access their test results? Well, the answer is it may be enough or it may not, and that's really going to be dependent on the medical provider. So I do recommend that in addition to having the designation of healthcare surrogate, your child also have a HIPAA authorization that is giving specific permission to you or whoever your child names to have access to HIPAA information to help them make an informed medical decision. So the people named as the surrogates are the same people that are authorized in the HIPAA document. The next medical advance directive for you to consider is a living will. Now, most people would tend to think of a living will as something that you wouldn't discuss and you wouldn't think about until you're very old, because they associate the document with death and dying. And that is true. This is a document that allows people to set out their preferences, their wishes for end-of-life care if they are determined to have a terminal illness, one that is going to shorten their normal life expectancy. I'm bringing this up in today's webinar because there are young adults who are diagnosed with a terminal illness that currently there is no cure for. And so I think it's important that people be involved, whatever their age, in directing the course of their medical treatment. So a living will allows us to have a discussion and to make decisions about medical choices such as artificial nutrition and hydration, if the illness affects our ability to safely swallow food and liquids by mouth. It allows us to make decisions about whether we want to be resuscitated if we stopped breathing or our heartbeat stopped. It allows us to think about and make decisions about if we'd like to be cared for by hospice services to treat us with dignity and respect through the dying process. And there are many other medical choices that can be addressed and made in the living will. There is no specific form or formula for a living will because it really should be tailored to each individual. And since we're all very unique, we all have different religions that we may participate in, it's important that the living will reflect the unique aspects of the individual. The third type of medical advance directive to consider is called a declaration of funeral designee, and this simply means that your young adult child will be choosing who he or she would like to make or implement end-of-life funeral arrangements should the child pass away. I know that these are very sensitive issues. They make us very uncomfortable to talk about, but I'd like to share a story with you just to demonstrate why this is important to have the conversation. Several years ago here in Broward County, there was a young man in his early 20s that was killed. His parents were divorced. They did not get along. The family was of the Jewish faith. One parent was very religious, the other was less religious, and they could not agree on whether their son's body was going to be buried or cremated. The parent, who was a devout Jew, wanted the son buried according to traditional Jewish law. The other parent wanted the son to be cremated. And because the son was an adult and he had no documentation in place and the parents could not agree, it ended up being brought before a probate judge here in Broward County. And I had the opportunity to listen in on one of the hearings, and it really was heartbreaking to see what this young man's death did to his parents to divide the family. It was also a challenge for the judge to determine what this young man would have wanted, because this is an issue that many people don't ever discuss, even in their later years of life. So I share that story with you just to simply suggest that we can all grow through having these conversations with our young adult children, with our spouses, and with the people that we're naming as our healthcare surrogates. Now, we've been talking today about our young adult children who turn 18. Let's not forget about our children that are minors, children that are under age 18. Now, while they don't have any legal rights as a child, we as parents make their medical decisions, we make financial decisions, we decide where they're going to school, who their pediatrician is going to be. There actually are some decisions we should be thinking about now. And again, Florida, about 2 years ago, finally realized that we need to have a law that will allow parents to designate a healthcare surrogate for their minor child should the parent be away, such as on a vacation. Maybe they're out of the country on business. So Florida allows us to designate a healthcare surrogate for our child who's under 18 and name a trusted person to make those temporary medical decisions, to be able to give consent to a pediatrician for treatment, or to be able to speak with the school and the school nurse's office. I think this is a great tool. I think it's something that's very important for all of us to have. And just like when we were discussing the designation of healthcare surrogate for an adult, it's very important for us to name that alternate surrogate for our minor child, just in case the first person that we've selected is not able to be the surrogate, or maybe not available, or maybe they're not in good health at the time that you're away. So we want to have a plan that is not going to fall apart. We want to have a plan that's solid, that's well thought out, and anticipates unknown events that may come in the future. So please think about designating a healthcare surrogate for your minor children under age 18. Another important document that we should have when we have young children is called a declaration of pre-need guardian for a minor. And what the phrase pre-need guardian means is that should the parent become incapacitated or unexpectedly pass away, whether from an illness, a disease, or a car accident, there is somebody named in a legal document to be our child's guardian, to raise them, to make their medical decisions, to decide where they're going to attend school, and to oversee any inheritance they might receive from the parent. In Florida, we do this in writing. It identifies the child by name, date of birth, and social security number, in addition to identifying the guardian or the guardians. Because again, we always want to think of having an alternate guardian, just like an alternate surrogate. Or we might want to name two people to be co-guardians. And there's no requirement that you need to name one person to be guardian of medical decision making and guardian of financial decision making. What's important is you pick the right and the best person for the types of decisions that need to be made. So you might pick one individual to make the healthcare, the residential, and the school decisions, and you might select a different person in the family or a close friend to be guardian over the assets. So I know it's a lot to think about, but I do want to encourage everybody to start to think about this and have the document created. Now, after parents sign the document, the attorney will electronically file it with the court, so it is a court record, and that's done, number one, because when the parent becomes incapacitated or passes away and the court is notified, they will immediately be able to locate the document. So even if the original cannot be found in the parent's home, we don't have to be concerned because it's actually an electronic court record. The second reason that it's so important is by law, filing this declaration of pre-need guardian for a minor creates a presumption that the judge should appoint the people that are named in the document. Now, anybody that is going to be a potential guardian when the time comes undergoes a background investigation. They have to be fingerprinted electronically, and those fingerprints are run through the FBI records as well as the Florida Department of Law Enforcement database. And we do this to make sure that the person the judge is going to appoint as the guardian is a person that can be trusted, a person that can handle responsibility. If the results of the background investigation are clean, then the presumption arises and the judge is required to appoint the people that are named in the document. If for any reason the background investigation shows that this proposed guardian has a past criminal record and was convicted of a felony, then the presumption does not allow the judge to appoint that first named guardian, and then we look to the alternate guardian. So it's very important that we have the primary named guardian as well as the alternate. So I'd like to conclude with an overview. We want to make sure that when our child becomes 18, a young adult, that we help them plan for their future, that we take the time, aside from the graduation party, the family vacation, or helping them prepare to enter the military, that we educate them about why it's so important to have the documents called the durable power of attorney for financial decision making, the designation of healthcare surrogate for medical decision making, and possibly a living will and a HIPAA authorization. If we have a child who's 18 as well as a younger child, then we want to make sure as parents that we've done the right thing and we've created a plan for our minor age children. This includes creating the designation of healthcare surrogate for a minor. So if we're temporarily away, somebody that we trust can make medical decisions for our child. And it also includes the declaration of pre-need guardian for a minor. And let's not forget about taking care of ourselves and having our own legal plan so that we truly can have peace of mind. So as adults and parents, we should also have a durable power of attorney, medical advance directives, and either a last will and testament or a trust in order to pass on our assets at death. And we may want to include some sort of a trust for our children's inheritance. We might want to have a trust for a minor so that they won't receive all the money when they're 18, but maybe we spread it out over a period of time to encourage them to attend college or a technical program, encourage them to become mature and responsible adults. We might need a special needs trust if we have a child who has a disability or some special needs. And there are many other kinds of trusts that we can draft to meet the needs of either a minor child or an adult child. So I'm very glad that you joined me today. I want to remind you that every week on Fridays, I host a weekly webinar series. You can go to my website to the events and calendar page to see the list of upcoming webinars and to register. If you missed a webinar and you were interested in the topic, you can go to our webinar page on the website and register to receive a password and be able to view all our recorded webinars. And please do share this information with your friends and family. When you visit the website, you can go to the Contact Us page and register to be emailed a free document checklist that will help you to start to organize your thoughts before you schedule a consultation, and we'll even send you a gift certificate for a 20% discount on either an estate planning consultation or a long-term care planning consultation. So I appreciate everybody who joined me today. And if there are any questions, this would be a good time. You're welcome to unmute your microphone, or you're welcome to use the chat box to write a question and send it to me.
Hi, Steph.
Hi, do we have a question today?
We do. It's Jill.
Hi, Jill.
So can you go back over for me declaration of funeral designation?
Yes, I'd be happy to. So this document serves two purposes. It will allow the adult to decide and state in the document, I either want my physical body to be buried at my death, or I want my physical body to be cremated at my death. And if the adult chooses cremation, then we want them to also decide who should the cremains be given to. If they choose burial, it's very helpful for them to think about and indicate in the document, do they want some sort of a memorial service? If so, where should that be held? Or would they like a celebration of life? The other purpose that the document serves is to actually name a trusted person to make and carry out the funeral arrangements. And this person will then have permission to speak with the funeral home or the medical examiner's office and to carry out the decisions that are made in the document. Plus, it gives the person the opportunity to also name the alternate decision maker so that there's always that backup plan.
And that's not included, Stephanie, in the durable power of attorney?
No, because the durable power of attorney for making financial decisions ends at death. It stops. We can no longer use it. That's why there is this separate document that can continue and pick up to take care of those final arrangements. Great question. Thank you, Jill, for asking that.
Thank you. Wow. So do you think a lot of people are aware of this document? I think not.
Probably not. And that's one of the reasons that we're hosting this topic today, so that more and more people do become aware. And hopefully it empowers people to be brave and talk about the things that can be uncomfortable to talk about.
Definitely. Wow. Okay. Great.
So if there are no other questions, I'm going to wish everybody a fantastic weekend. Keep taking care of yourself, keep practicing self-care, stay healthy, and stay safe. And thank you for joining me.
Thank you.